a number of regulators have been calling for increased regulation or to speed up some of the rulemaking in Dodd-Frank. Congress has gotten involved, and a number of members have said that the future space needs to be re-examined in light of the MF Global bankruptcy, and that maybe Dodd-Frank doesn't go far enough. Or again, at a minimum, a number of legislators have indicated that Dodd-Frank and the regulations need to get done as soon as possible, and that there can be no more delay. First and foremost is the Volcker Rule, which is not yet in place. As you may know, the Volcker Rule states that an investment bank can't have a proprietary trading operation. If you're doing customer business, then you have to have that separate. You have to spin it off, and a number of investment banks have been doing that. It applies to a certain size investment bank. So MF Global would not, it's my understanding, would not have been subject to the Volcker Rule. It's possible, certainly, some legislators could look at that and say, well, in light of MF Global and the issue with the customer funds, it's time to make the Volcker Rule apply to a broader audience of participants. Rule 1.25, which relates to what an FCM can invest in. FCMs were only allowed to invest in fixed income instruments, treasuries. Over the years that evolved, and the regulators allowed FCMs to invest in things like agency debt, money market mutual funds, foreign sovereign debt, in addition to the treasuries. There's a good-sized list of investments that FCMs had the option to pursue. Now, most recently, as of a year ago, the CFTC has examined this rule and is narrowing that definition. So it went from small to a good size list of investments, and now it's going back. They're reducing the list. As a part of the proposed amendments to Rule 1.25, the CFTC, at the mandate of Congress, has taken out the credit rating concept. And the reason for that is because of the conflicts of interest seen with the credit rating agencies and some of the issues that have evolved over the last few years with credit rating agencies. And so anything and everything in regulations, not only with the CFTC, but anywhere within government regulations, any reliance on credit rating agencies had to be taken out of those regulations, and new concepts had to be followed, had to be developed or inserted in place of the credit rating agencies. There are a number of conflict of interest proposals out there. Most notably, the CFTC has issued proposed rules relating to research at FCMs, and in particular, similar to what they're doing, to what has been done in the securities world, Congress wants to make sure that brokers do not bias their research to favor their brokers. They don't want the trading side of the FCM to strong-arm the research side into saying certain things or to making certain recommendations just to favor the trading side. There's a proposal out that mandates that FCMs and swap dealers and major swap participants all have chief compliance officers, and these individuals, it's not unlike Sarbanes-Oxley, where you have the CFO who has to sign an annual statement certifying to the validity and that the audit is proper. Same thing as proposed by the CFTC as to compliance officers. They're going to need to sign an annual statement certifying to certain compliance rules and that the certain compliance guidelines have been followed. One issue that the CFTC has been examining and has put out a proposed rule on relates to segregation of customer accounts. We've heard a lot about that, and what does that mean? It means that customer funds need to be separate from the firm's assets. Customer assets and firm assets need to be segregated. The firm is not allowed to use customer assets for its own purposes, for anything, for trading, for operations, etc. Currently, in the futures space, it's what's known as an omnibus approach toward segregation. So all the customer funds are pooled and effectively mutualized. It's almost like an insurance company. You're put in with your fellow futures traders at the firm level and also at the clearinghouse level. And if someone goes belly up, if it's big enough, they can the FCM or the clearinghouse can draw from others within the pool. Now there are different rules out that are examining whether that's proper and whether they call it a waterfall approach. Where in the waterfall should the customer funds be? You have different funds that you can access. The clearinghouse most clearinghouses have guarantee funds. Some have insurance policies, etc. The FCMs, you can also look to their assets, their firm assets, as well as their customer assets. The CFTC has thrown out some proposals such as individual segregation. It's almost like having your own IRA. So everybody would have their own segregated account effectively with their name on it, again at the FCM level and at the clearinghouse level. So you would always know specifically where your assets are located. And in that case, it wouldn't be a mutualized system. Each individual is responsible for themselves. And if someone blows up their account, assuming you can't get money from them, then perhaps the clearing firm would have to make good for that, or others. It's again, that's a debatable point that's being considered and discussed by the CFTC right now.